Lastly, this is the panel of the judges who will hear your case. Look at them carefully. If you have any objection to any of the members, you will say so. But if you don't put the reason why, I'm starting with you, Hajji Besigye. Do you have any objection to any of the members?
I don't know who the members are. I know who they are before I raise an objection to other ones.
They are here. Look at them.
Mr. Chairman, this may go to the issue of names, ranks, introducing the panel. Really, I do think.
We can provide the list of the panel to your defense lawyers.
The question I've been asked is whether I object or not. I cannot object to what I don't know.
I think I will not waste your time. You can start, you say, Freeman, the chairman, and all other members. If we have a result, those will be.
Is that what we are talking about? Brigadier General Robert Freeman, Chair General Commercial.
Major Richard Triagwe, I'm a member.
Captain Abdallah Sajawaraba, member.
Warrant Officer 1, Mr. Robert Nyalali, member.
Major Sarasoko, member.
Lieutenant Colonel Sam Dungura, political commissar, member.
Captain Marian Makindye, member.
Warrant Officer 1 of the Airport Department.
Captain Christina Sayuni, member.
Warrant Officer 1 of the Airport Department. Now, the question is back to you. We have any objection? Any of the members have introduced themselves?
Does the court have more members than have been introduced? Because if they do, we want to know all the members of the court, whether they are here or whether they are not here, so that we can object or not object, since they are interchangeable.
That's right, Colonel. It is Colonel Okarebo, who I have not seen him today, and there is Captain Nekore.
I think, sir, on our proceedings, the key issue is that the court is composed of 7 members. We have the members themselves, they are present, and the court is duly constituted. So we'll go ahead on the next stage of responding to the questions.
Mr. Chairman, the assumption then is that the members of the panel, as duly established today, and those the 2 results, will not change, because our clients are objective or not objective to the ones who have been introduced. The request that is made that will be a constant panel.
Exactly. That is how we do it.
Right? Mr. Chairman, objection.
Yeah, I know.
The court makes the pronouncement.
Yes, it will be like that.
Most of like
Yes.
Back at your finding. Do you have any objection to the of the members and reserved members who have introduced themselves?
No.
Has no objection. A1, sir. Captain Nora, do you have any objection to any of the members who have introduced themselves?
No.
Captain Nora has no objection. Obed Lutale, do you have any objection to the members who have introduced themselves to you?
no.
Captain Lutale has no objection to the panel.
The Republic of Uganda, Uganda People's Defense Forces, the General Court Martial, Warden at Makindye, Kampala. Criminal case number EPDF/TCM/040 of 2024. Dated today. Amended charge sheet. Uganda versus A1, RO1274, 3, Captain Dennis Oral. Male adult Ugandan of sound mind, age of 48 years. Mr. Rofi is attached to Ahmad Brigade, person subject to Mr. Law. A2ROV 0098, Colonel Judge Dr. Kizza Besigye, male adult Ugandan of sound mind, age 67 years, resident of Kasanga Town, Nangabo Sub-County, Nansana Municipality of the District, a person subject to Mr. Law, by what of Section 117, subsection 1G, Cap 330. A3 Hajji Obed Lutale, male adult Ugandan of sound mind, age 65 years, resident of Mutual Parish, Makindye Sabagao, Sub-County, Ciro County, of Sub-District, a person subject to Mr. Law, by what of Section 117, subsection 1G, I of the EPDF Act, Cap 330. Statement of offense, count 1. Offense is relating to security under section 128, subsection 1F, the EPDF Act, Cap 330. Particulars of offense. Captain Dennis Oral, Colonel Retired Dr. Kizza Besigye, and Hajji Obed Lutale between February 2023 and November 2024, while in the cities to wit Geneva in Switzerland, Athens in Greece, Nairobi in Kenya, and in diverse places of Kampala metropolitan, in Uganda held meetings aimed at soliciting logistical support and identifying military targets in Uganda with intent to introduce the security of the defense forces. Captain Dennis Oral, have you heard?
Captain Oral, I'm only privy to the amendment now. I humbly request that I interact with him and guide him. Thereafter, I shall formalize the instructions, if you please.
How long are you?
Just a few minutes. About 2 minutes. Much of that. Madam Chairman, we may now proceed.
Once again, Captain Dennis Kora, have you had understood the judgment you will go on?
Yes, I've understood.
Do you accept or don't accept?
I don't accept. I don't accept.
You have not visited the entity. Colonel retired Dr. Kizza Besigye, have you had understood the judgment you will go on?
I have heard and I have issues with the charges which my lawyers present to me.
I think that you will address when time comes.
Sir Chairman, we have objection to be taken, grounded on Regulation 23 of the regulations of this court martial, particularly sub-regulation 1, that before pleading to the charge, the accused may offer a plea to the jurisdiction of the court before taking the plea. The accused may raise the question of jurisdiction. Mr. Chairman, is on record. We have already raised issues to do with territorial jurisdiction of this honorable court. And there is a ruling which is pending before this honorable court, which is not delivered. That this honorable court has got no jurisdiction to entertain matters which are alleged to have been committed in Athens, in Switzerland, in Kenya. We have raised that issue before you, and this honorable court-martial has not pronounced itself on the matter. So it will be a violation of Regulation 23 for the accused person to proceed and make a plea before the ruling is delivered.
Are you not taking us, counsel? Are you not taking us in hand? It is pre-taking. You can say yes or no. Then we can start from there.
I think, sir,
Mr. Chairman, the rule is before pleading to a charge, the accused may offer a plea to the jurisdiction. That is the rule, and this is what I'm quoting. And oftentimes this court-martial has reminded us to abide by these rules, and the judge advocate is so passionate about these regulations. I hope this time round is going to appropriate that advice of this honorable court-martial, that it's within the accused's right not to take a plea until the ruling is delivered from the territorial jurisdiction.
I'm reminding the counsel Kwabo that the accused himself mentioned that objection. I'm the one talking. Objection. No, you cannot object when I'm talking. Objection.
Can you listen and efficient what is
You have not raised anything.
you have not heard what that is saying, now what are you objecting without even listening to what is saying?
I can confidently tell this court and those who are present that the matter was raised and the court ruled on the matter. Registrar, can you avail the ruling that was raised on objecting to jurisdiction by this court? Just to remind you, you read the ruling and when it was delivered. And we proceed.
Mr. Chairman, objection. Mr. Chairman.
Please, hold on and you wait for the nearest registrar to read the ruling. That one will not stop you from submitting on what you want to submit. But first,
My Lord, with your permission, we proceed with the ruling. The Republic of Uganda, by the political forces, in the
Court Master for the Makindye. Criminal case number EPF is sent to the court 2024. Uganda, represented by Prosecutor versus A1, ROB 0098. Colonel retired Dr. Kizza Besigye. A2, Hajji Obed Lutale, accused person. Ruling on application made by Counsel Elias Kwako.
There was a ruling raised on the jurisdiction of the court. Not the one of Rupaku. The one of Rupaku is not yet ready.
We are also interested in that one. If it is ready, we have been asking for it since morning.
I think if you don't have it there, you go to consult your file.
Why are you standing for? Get that ruling in the registrar so that we don't proceed. That ruling is
When the court wanted to read it, you didn't want it. Now we are all retaking against the judge when the ruling is now proceedings like I think, sir, for me, as president of this court, the registrar is even under my office, and I am reading it is here. I have not written it now. So the ruling was pronounced by court. It is that the who raised it himself from day one. So it shouldn't be a point of saying that you are raising it now. What is the donation?
Oh, possibly.
If you don't have the record saying, go and find the people.
My Lord, on 20th November 2024, A1 by then was retired Colonel Dr. Kizza Besigye. He objected to all the court members.
I'm still what counsel is doing there. I fail to understand. Do you think he's reading what is not written? I thought you were supposed to build a landscape.
Subjected to both the court panel and jurisdiction. Given A2, who is now A3, raised the same objection. J guided that the accused have to give reasons for the objections as regards the court's panel and jurisdiction. A1 stated that it's a military court and I'm not a member of a military. I believe I should be tried by civilian court. A2 stated the same. J guided that state had to give a reply to the objections. State replied as follows. It captures the concerns of the jurisdiction. Background. States have admitted that the object is one, the objection is one, and the reply they stated as follows. That the enabling law, which is section 117, applies all the accused persons, that is A1 and A2, and then what were referred to. He also proceeded as state and informed court that he did not even know the lawyers that were representing the accused persons. Then J guided that court had to close for the deliberation and make the ruling. Counsel Kwaku submitted that they had no opportunity to meet the accused persons. To hear their story and get full instructions. He asserted that lawyers as a practice, they proceed with instructions. He proceeded to report that A1, as then was Dr. Kizza Besigye, and his colleague, by then was A2.
Those are different issues now. Because for me, I'm always in this court. And what I have is that court and judge gave the objection, court came and gave the witness, and I have the ruling here. The court said they are subject to military law under section 117G and H of manipulative statute. That was the ruling of court.
Mr. Chairman, the judge advocates by law not a record keeper. We cannot assume the role of the registrar with respect, and therefore the registrar is under your office, but you cannot, the law does not allow you to come to court and be an advisor as well as a record keeper.
I'm the one who's providing the record.
My Lord, the ruling briefly is that after 5 minutes deliberation.
Mr. Chairman, with your permission, if I may just correct my friend from the registry. When we were here last week, court adjourned the handing down of the ruling so that we could consult the accused persons who were two at the time regarding the instructions of counsel to receive the ruling. It might be recalled, Mr. Chairman, that when court asked or pointed out to my senior colleague, Mr. Kwabo, why there should be an adjournment, we did point out that we who were present, myself and Mr. Katumba, in the absence of Mr. Kalibala, who were counsel on the record at the time, were not in court when those objections were made. When we returned, the court adjourned to today without delivering the ruling and moved on to determine the matter of Mr. Aaron Kizza. So there was no handing down of the ruling. Now, my concern as counsel for the accused persons is that we understand that it should be the court to hand down the ruling. When the judge advocate insists that his office has the ruling, which has not been handed down by the court, Mr. Chairman, it points to the impartiality of court, and any other person who follows these proceedings on TikTok and whom will only see this caption might think that it is the office of the JA which perhaps writes the rulings for the court. I think that is a grave concern which we need for the sanctity of these proceedings to remind ourselves the role of the court and our land colleague, the judge advocates. Otherwise, it is not a little, it is of much concern, Mr. Chairman, when the registry, which should be the central collection of proceedings for the day, appears to have no ruling. The court, led by your leadership, Mr. Chairman, does not recall reading or has no ruling. And yet, the advisor of the court insists that for him he has the ruling. It is, again, Mr. Chairman, we did remind ourselves that we, as lawyers, may understand the omissions, but to someone who is in the dock, who is a businessman, a doctor, a gallant soldier, who doesn't understand these proceedings, might think that this is a pre-arranged session. It is a little concern, and again, we wouldn't want, because it will be the third time. Sometimes, rather than going what we are going through, perhaps the court to retreat a little, just to put his house in order, because now we are pulling rope, and it doesn't appear quite nice. It's my
My lord and members, make it clear. On the first day, the accused persons were not represented, and that's when he raised the objection to Nixon. And on the same day also, Lord Mayor, as then was now his counsel, also raised objections. So there were two rulings. One was given, another one was pending. So the one that I'm reading today was giving the background what happened in court, and then another one you haven't given also to read. So I pray to proceed with the one on jurisdiction that was raised by accused persons at the time who were not represented. Citing section 117 of the UPDF Act Cap 330, court ruled that this honorable court had jurisdiction and has jurisdiction over the accused persons since they are all subject to military law by virtue of the same section. And ended there. And he proceeded and read the charges the accused persons, to which they all pleaded not guilty. And then that's when Lukwago Elias, with due respect, nobody was not counsel, had no instructions, proceeded and also raised some objections as pertaining to the charges. That's what we have.
I think I have indicated. Yes, because I was the one who registrar. Why are you saying that I'm writing my own things?
That one was finished. Let us proceed. I was council seat. I was asking the Colonel that Kizza Besigye, have you had understood the charge return round one?
I have heard and I have responded that I have objections to taking plea on this charge and requesting my lawyers present my objections.
You are right, but at this moment I'm asking you, the accused person, if you don't accept, you say I don't accept. If you accept, you say yes, I accept.
Accept what?
There are two things. If you have had an understood, another question is, do you accept or you don't accept?
Accept what?
With your help to you, Mr.
Do I
Chairman.
plead guilty or not guilty? Or you want me to take a plea?
He has invoked Rule 23 that he is objecting to taking plea.
Yes.
And therefore it may not be fair to ask him whether he accepts when he clearly invokes Rule 23 and it allows him to do what he is doing. So maybe you could allow, on his behalf, Counsel Elias Lukwago raise the objections on his behalf as he has asked, as he instructed us to.
What the registrar has read is the same objection that was overruled. So we are going to go back where we started from.
Please, no, I've not allowed anybody now to go.
Thank you, Mr. Chair.
Because now you are taking us backwards.
It's a new charge.
Yes, it is a new charge. Now what you've said, just now the one you are pushing for is corrected. Will he accept or he will not accept? So the issue is, we have read the charge. It is the accused person to plead guilty or not to plead guilty, and then you can start from there.
Mr. Chairman, with your permission, humbly. Thank you very much, Mr. Chairman. Mr. Chairman, my learned friend, the JA, rightly pointed to the court adopting rules of amendment on criminal charges, and also pointed out to any amendment which can be done which doesn't prejudice the accused person. That is correct, and it's on that basis that the court made a ruling regarding amendment. My colleague will agree that once an amendment has been made, the process which was running before comes to an end and starts afresh with the new amendment. The charges we have now, clearly from looking at the amended charge dated today and the one before, are distinct. So essentially what the prosecutor has done is to start again the process which started in November. So the objections which were made then, if any, cannot be carried on by infection to the current charge sheet. To the extent that the accused person has seen and has new objections, because this is now a fresh charge sheet, Mr. Chairman, as the JA will agree with me, they are entitled to make the objections. They might be boring, they might be the same, they might be repetitive, but in a dispensation when we are saying it is his right, it is his right to make the objection. What we request is for court to listen kindly, and then also, as my learned friend has advised, and the JA, if we do it together, Regulation 23, kindly. It says, Mr. Chairman, before pleading to the charge, before pleading to the charge. The accused person may offer a plea to the jurisdiction, and if he does so, the accused person may adduce evidence in support of the plea, and the prosecutor may adduce evidence in answer to that evidence, and the prosecutor may address the court in answer to the plea, and the accused may reply. Mr. Chairman, Regulation 23(1) applies before taking the plea. It is not even saying at the time, it says before. It also says that the accused person may. When it applies may, Mr. Chairman, it gives the accused person a discretion. What we understand now, Mr. Chairman and members of the court, is that the accused person has chosen to exercise their right to raise an objection. We have not listened to the objection because, according to the accused person in the dock, he has asked his lawyer to make the objection. So, my Lord, in that regard, we would be inclined, if we are to agree that we follow this procedure of this court, we are enjoined to listen so that the state may respond, and then the court will make a pronouncement. That is what, Mr. Chairman, we understand from the clear it is before. So, Mr. Chairman, when the accused is asked whether he understands, we understand that to be part of the plea-taking process. Yet the rule requires that before that process begins, he has the right to raise objection. We humbly pray, Mr. Chairman, that we abide by this regulation. We kindly request it, Mr. Chairman. Thank you, Mr. Chairman.
I also concur with the counsel. FK. You raise your objections, let the state reply.
Mr. Chairman, the humble submission of the guilty persons that this Honorable Court Martial has got no territorial jurisdiction to entertain the charges as spelled out in the charge sheet, and it would be violation of Article 23 and 28 of the Constitution of the Republic of Uganda if you proceeded to entertain this matter. Mr. Chairman, the Constitution confirms the jurisdiction of this Honorable Court Martial to matters relating to offences allegedly committed within the territory of Uganda. Mr. Chairman, under Article 23, 28, 28:12, no person shall be convicted of a criminal offense unless the offense is defined and the penalty for it prescribed by law. And also, yes, I'm coming to Article 28:7 as well. If I may be permitted to make my case. No person shall be charged with or convicted of a criminal offense which is founded on an act or commission that did not, at the time it took place, constitute a criminal offense. Mr. Chairman, when you look at the charge sheet, the particulars allege that while in Athens and in Greece, rather in Geneva, Switzerland, and also Kenya, in Nairobi, Kenya, they accused the persons alleged to have committed those offenses, particularly the allegations that they were found in possession of weapons which are ordinarily a monopoly of defense forces. Mr. Chairman, weapons in Kenya, or military hardware in Kenya, or Athens, or in Geneva, cannot be a monopoly of UPDF. The UPDF Act specifically talks about weapons which are a monopoly of UPDF, not the defense forces or security forces of Switzerland, of Greece, or of Kenya. When you look at the provisions of Article 28:7, those acts, the impandi acts spelled out in the charge sheet, would only constitute offenses in those countries, either in Kenya, in Greece, in Switzerland, or in Greece. Because, Mr. Chairman, the particulars here, we are talking to Colonel Dr. Kizza Besigye, while at Riverside apartment in Nairobi, Kenya, we are found in unlawful possession of a pistol model this, which is ordinarily a monopoly of the defense forces. Mr. Chairman, this one has two limbs. One, the defense forces are not defined. Are you talking about the defense forces of Uganda, of Kenya, of Greece, or of Switzerland? They are not defined here. And that touches on two issues. One of jurisdiction, but also on regulations, particularly Regulation 22. Regulation 22 provides as follows. An accused may, before pleading to a charge, object to it on the grounds that it's not correct in law or that it's not framed in accordance with these regulations. And if he does so, the prosecutor may address the court in answer to the objection, and the accused may reply to the prosecutor's address. This is Regulation 22 of your regulations here. An accused may, before pleading to the charge, object to it on grounds that it is not correct in law and that it is not framed in accordance with these regulations. So this is a defective charge sheet. This is our contention, Mr. Chairman, that it's not framed in accordance with the UPDF. Rather, with the UPDF Act. It's not framed in accordance with the UPDF Act of 2005 because it is purporting to bring into the confines of this court, the jurisdiction of court, matters which relate to weapons of other countries, defense forces. It could be KDF, that is Kenya Defense Forces, or elsewhere. Because if it were a charge sheet relating to offenses under the UPDF Act, specifically they would state it here that contrary to a particular provision which talks about weapons which are ordinarily a monopoly of the UPDF. But here they are talking to contrary to defense forces. So the presumption is that this court martial has jurisdiction all over the world. That is universal jurisdiction. That whoever is found in possession of any weapon which is alleged to be a monopoly of defense forces, not UPDF, or defense forces worldwide, then this honorable court martial has got jurisdiction to deal with that. So that offense, regulation 22, and the charge sheet becomes defective. It's not correct in law. It's not framed in accordance with the. It's not framed in accordance with the UPDF Act. Then the other limb of the argument, Mr. Chairman, is in relation to the way the accused persons were transferred from Kenya and brought here. Mr. Chairman, our contention is that this honorable court martial has no jurisdiction whatsoever to deal with accused persons who are not processed in accordance with the laws of Uganda or who are handled in a manner that violates international law. And I will refer you to a number of authorities which we have here. Mr. Chairman, I have the Ugandan case of Omar Owadi and 10 others versus the Attorney General. It's a consolidated constitutional petition number 55 and 56 of 2011. But Mr. Chairman, here reference was made to a number of decisions that have been taken by other Commonwealth countries which we find to be persuasive. First of all, Mr. Chairman, they made reference to the case of Regina versus Hosife Road Magistrates Court. It's 1994, SC, Volume 1, page 42, where the House of Lords gave a genesis to the jurisprudence relating to matters of this nature. And this is what they had to say. English common law regarding irregular apprehension of an offender abroad and the jurisdiction of English courts to try such an offender was examined by the House of Lords in that case of Regina versus Hosfeld. The earlier approach of the English courts had been that once a suspect is in lawful custody in that country and charged with an offense which that court has jurisdiction to hear, the court has no power and is not concerned to inquire into the circumstances in which he may have been brought into its jurisdiction. It was no answer to a charge that such person was arrested or kidnapped contrary to the laws of the state of refuge. That was the jurisprudence and the practice at the day. And the House of Lords had to reverse that position and this is what is hard to state, which is now the common law position on issues to do with the people picked from other jurisdictions and tried elsewhere. That whatever differences there may be between the legal systems of South Africa, the United States, New Zealand, and this country, many basic principles to which they seek to give effect stem from common law roots. There is, I think, no principle more basic to any proper system of law than the maintenance of the rule of law itself. When it is shown that, and this is the principle, when it is shown that the law enforcement agents responsible for bringing a prosecution has only been enabled to do so by participating in violations of international law and of the laws of another state in order to secure the presence of the accused persons within the territorial jurisdiction of the court, I think that respect for the rule of law demands that the court take cognizance of the circumstances. To hold that the court may turn a blind eye to executive lawlessness, it would again appear to me to be a very inadequate response for the court to hold that the only remedy lies in civil proceedings against the individual offenders of the law enforcement agents who are concerned with the illegal actions taken. And this was also reinforced, Mr. Chairman, in the case of it was reinforced, Mr. Chairman, in the case of State versus Ibrahim. This is a South African case. The citation is there, where court held that we also consider established the principles that a court has no jurisdiction. Allow this stand up after Mr. Chairman. We also consider established the principle that a court has no jurisdiction to try a person who was abducted from another jurisdiction by agents of the state authority exercising power in the area of the jurisdiction of the court. And that abduction, kidnapping, represents a grave contravention of international law, the Committee of Nations, and the rule of law generally. They made reference to the aforesaid case of Regina Hospital. We observe that courts in this country have scrupulously reaffirmed the need to observe the rule of law and prevent the abuse of the court process. The case of Dr. Kizza Besigye versus the Attorney General Supra has held that this court is obliged to intervene and even state proceedings where the abuse of the court process is such that no fair trial can be achieved. This principle was reaffirmed by the Supreme Court in Kizza Besigye and others versus the Attorney General, Constitutional Appeal number 1 of 2006. This is the position the Constitutional Court adopted, one in Dr. Kizza Besigye's case, but also the position that has been well established in all Commonwealth countries or jurisdictions, that once the accused persons are illegally brought before court in violation of international law and they have been kidnapped and illegally extradited, then that court has no jurisdiction to deal with the same. We are making reference to the Extradition Act, a copy of which, Mr. Chairman, I'm sure you have, which clearly makes provisions on how accused individuals or citizens of a particular country, Ugandans, who are alleged to have committed offense outside the country are supposed to be transferred back to the country where they should be charged. One, this Extradition Act, Mr. Chairman, talks about a fugitive criminal, that one must have been a fugitive criminal to be subjected to extradition. It's abundantly clear that at no one moment has this court-martial been presented with a record that prior to their production before this court, that they were criminals, they were fugitive criminals who had pending charges that required their extradition. And even if that were to be the case, Mr. Chairman, the Extradition Act provides for the procedure on how this should be done, which involves the judicial process, that you go through the processes of the judiciary in Kenya, where they were arrested from, present them before the law, a warrant is made, and upon a request made by the domestic minister here to the counterpart in Kenya, requesting that commence the process of extraditing that fugitive criminal who is within your territory, your jurisdiction. That is what is provided for in the Extradition Act which we have here. This was never the case. There were no extradition proceedings in Kenya, and therefore they were not legally transferred back here. The other option would be deportation. Mr. Chairman and honorable members, if indeed they were found to have entered Kenya illegally, or if they entered Kenya illegal and committed the offences as alleged in the charge sheet, that they were found in possession of firearms, which are ordinarily a monopoly of defensive forces, this could be the defense forces of Kenya. That would constitute an offense in Kenya, and they would be prosecuted in the courts of Kenya. And if the courts of Kenya deem it necessary and appropriate to have them deported to their country of origin, they would issue those court orders. That so Dr. Besigye and Obed Lutale, having committed such and such offense, you are hereby deported. There is no deportation order, there is no extradition warrant. So these accused persons were illegally brought here before you, and now the charge sheet prepared is in reference to offences allegedly committed in Kenya. The authorities we have cited here are very, very clear that you do not have jurisdiction in such cases. The one we have talked about of South Africa, it involved the illegal readmission of a particular individual from a neighboring country to South Africa. You will find it, the facts you will find them in that particular case. The case was dismissed and said this is illegal because since there was kidnapping of this particular individual from a neighboring country and brought to South Africa, they couldn't be tried in South Africa. It is the case here. Now you are being asked, Mr. Chairman, to entertain and try a matter which did not go through those legal processes, which is a violation of international law and a violation of our constitution, and essentially the proceedings are rooted in a narrative where you do not have jurisdiction to handle this matter. So that is our contention in this particular case, and it is the reason we are saying at this stage, under Regulation 22 and 23, Dr. Besigye and Obed Lutale are not taking a plea to charges which are penalty, charges which are duplex, charges which offend the laws of Uganda and the international law. So we pray that you be pleased to strike out the charge sheet, Mr. Chairman, and discharge the accused person. We do so.
If I may add to that, just to confirm that the extradition law of Kenya is similar to that of Uganda. That the constitution of Kenya is similar in terms of right and the requirements of due process to the constitution of Uganda. In both countries, due process is emphasized. And therefore, as has been ably demonstrated by Council Elias Lukwago, the fact that agents of the state of Uganda arrested or abducted the two gentlemen from Kenya and brought him back without any court order from Kenya. Because even where the states have an extradition treaty, you still have to present a person to the court in the country of arrest. So they ought to have been presented to a court in Nairobi, and that court is the one that would have ordered for their being brought to Uganda. In that court, these two gentlemen would have had the opportunity to object to their being brought. They would have had a say. But now they were brought against their will. And the state, the arresting authorities, have actually violated the constitutions of Kenya and laws, the constitution and laws of Uganda, and the laws of the East Africa community. The Constitutive Act, Article 6 and 7, the rule of law principle, has been violated by renditioning Dr. Kizza Besigye and Obed Lutale from Kenya. What if the arms alleged to belong to defense forces belonged to the defense forces of Kenya? Would it be a criminal offense triable in Uganda? Those are the issues. That's why in each country, jurisdiction is territorial, within the territory. I know the UPDF Act does talk of beyond its jurisdiction, but that is also a constitutional question. If you look at the Constitution of Uganda, Article 126, judicial power, Article 129, the courts of judicature. It's clear that judicial power of Uganda shall be exercised by the courts of judicature, which shall consist of Supreme Court of Uganda, Court of Appeal of Uganda, High Court of Uganda, and such subordinate courts as Parliament may by law establish, including Kadhi's Court for marriage and divorce, and inheritance and guardianship. But I want here to agree that the UPDF courts are such subordinate courts set by law. But those courts, just like all the other, I don't know whether that will affect the record. It's back. What it means, Mr. Chairman and the court, is that your territorial jurisdiction as a general court martial is limited to the territory of Uganda. And therefore, if someone is brought from another country, like they were brought from Kenya, and if offenses are said to have been committed in Kenya, in Greece, and in Switzerland, you have no jurisdiction, because the Constitution of Uganda says so. the jurisdiction of the courts in Uganda is for Uganda territory. So we are asking you to strike out these charges so that our clients do not have to plead to defective charges, and to also put weight on the submissions of various requirements, on the fact that even if you have jurisdiction and we submit you do not, the fact that they were illegally brought here, the state is not permitted in law to commit a criminal offense or to violate the law in the name of apprehending offenders. You cannot violate the law under the guise of enforcing the law. Bringing them without a court warrant, from Kenya, without extradition and a court order is a violation of the law. And therefore these charges cannot be entertained. The second schedule to the Constitution of Uganda clearly says, and it's pursuant to Article 5, it gives the boundaries of Uganda. I will not read, it's a long description of the boundaries of Uganda, but I refer you to it so that you find Nairobi is not within Uganda. And any offense committed in Nairobi is up to the authorities in Nairobi to prosecute somebody in the courts of Kenya. So you are sitting, you are being asked to take plea on a matter for which this court-martial and all courts in Uganda have no jurisdiction whatsoever. If it is in Athens, the courts in Greece will have jurisdiction. If it's in Switzerland, the courts in Switzerland will have jurisdiction, not the courts in Uganda. And the UPDF Act, made pursuant to the Constitution of Uganda, cannot amend the Constitution of Uganda. So if the Constitution gives territorial jurisdiction of the courts as Uganda, the amendment of the UPDF Act, which seems to expand the jurisdiction of this court beyond Ugandan territory, is unconstitutional. It must defer to the Constitution, and these charges must be thrown out. I give way to any colleague who may have something to add.
Honorable Chairman, honorable members, just to supplement, we are alive to a provision in the PDF.
My Lord, maybe before the supplement, you wait for the judge, because
he's
he's in charge of guidance on the land procedure.
Let's wait for him.
Supplementing what my colleagues have submitted, we are also alive to section 208. Those two sections appear on the face of it to grant jurisdiction offenses outside Uganda, but we contend that if that is the interpretation given by this court, those sections, then they are inconsistent with the two articles of the Constitution. Constitution, Article 79, the powers of Parliament, which are restricted to good governance of Uganda, and then Article 129 that my colleague has explained on the exercise of judicial power of Uganda. So the finding of the court, the view of the court is that those two sections do away with the objection that we are raising. We are giving advance notice that we will seek interpretation of those two sections compared to section 9.
Jurisdiction, as earlier is a breacher of statute. And as Ms. Bakaribara put it, section 208 of UPDF Act empowers us, which awaits that a person alleged to have committed a service offense may be charged, dealt with, and tried under military law, whether the alleged offense was committed in Uganda or out of Uganda. And we are saying Greece, Kenya, and Switzerland, indeed they are out of Uganda. But it is provided by the law. And it is not this court that has those powers to repeal this law. When this law was passed, I believe Council could have been one of those that were in Parliament, probably have boycotted the parliamentary sessions. But it was there, it is there. There is that post. I don't know whether he read it, and it is not in this court where he can bring his unconstitutionality. Yet he knows where it is supposed to be in case it is unconstitutional. Section, so that one, in regard to territorial jurisdiction, Chairman and court members, we have the jurisdiction. You also talked of defense forces. Is it the defense forces of Kenya, Switzerland, and where? The Act here defines what the defense forces is. Section 2 of UPDF Act Section 1 defines defense forces means the Uganda People's Defense Forces. So these people, the suspects are charged under the UPDF Act. Therefore, there is no question of saying, are these Kenya People's Defense Forces? Is it a monopoly of Switzerland Defense Forces? The Act is very clear. Chairman and court members, Section 117G gives powers to this court, the court martial, to try people who are not otherwise subject to military law, but they become subject to military law. That is due. Every person not otherwise subject to military law who aids or abets a person subject to military law in the commission of a service offense. And H, every person found in unlawful possession of arms, ammunition, equipment, ordinarily being the monopoly of the defense forces. And the defense forces is already defined. We also talked about how these people appeared before this honorable court, that it was unlawful. Unless it proves otherwise, but we believe and we are contented that these people were brought here lawfully. Other than the extradition treaty, there are other interstate arrangements which are in the place that between the two countries on border, in the border crime to do with terrorism and security-related matters. There is a memorandum of understanding between the two countries, and it is clear to those who are. So, to do with how the accused persons arrived here, chairman and other court members, was an interstate arrangement that began to be here. So the constitutionality question, chairman and other court members, addressed by this honorable court. The provision of the Refugee Act that contravenes the Constitution, which I believe is not there, because Senior Counsel Kaba was quoting the Constitution that it limits, it provides jurisdiction, but she did not quote the particular provision. Territorial. No. So it is not applicable in this matter. I have no back to my colleagues.
My Lord Chairman and honorable court members, I begin with to respond to Honorable Elias Lukwago's submission on the propriety of the charge sheet regarding Regulation 22 of the EPDF Rules of Procedural Regulations. Honorable Lukwago is of opinion that the charge is defective and complex, and said it does not comply with the regulation. Mr. Chairman and members, in making his case, he did not refer to which regulations the charge sheet does not comply with. Reading Regulation 22 that he cited, it talks about compliance with the regulations, these regulations. And my lord, in the regulations, framing charges is governed by Regulation 6, Regulation 7, 8, and 9. And Counsel Lukwago has not shown how these provisions are violated by this charge sheet. Counsel Lukwago also says the charge sheet is duplex. our understanding of a duplex charge is one which introduces two charges in one count. But his submission has not spelled any such in his charge sheet. So we maintain that the charge sheet is proper. Honorable Council Wago, together with Senior Council Makindye, talked about the production of the accused persons before this court as being illegal. However, Mr. Chairman and members, the issue of illegality is a matter that needs to be established by evidence. And that's what we shall establish if this matter comes for hearing. It is not a matter that can be just determined at this point. And their decisions, Honorable, for also relied on the House of Lords decision on Regina versus Hospital Districts. On how the House of Lords departed from the common law position. Mr. Chairman and members, we respect that decision, but it applies to the law in England. It is not the position in East Africa. The position in East Africa, we have case law. We have a Tanzanian decision of Mataka versus Zimbabwe. It's a reported East African case. Where the East African Court of Appeal pronounced itself that once a person has been brought before the court, the issues of how he was arrested do not bar trial. It is reported in 1971 East African Law Reports at page 497. The issue regarded one of the accused persons called Mr. Chipaka, who was charged with treason. I also associate with my senior friend for the state about the position on extradition law. We maintain that extradition law is not the only mechanism dealing with transborder crime. There are other mechanisms like interstate arrangements, and they are also authorized by the East African protocols. Mr. Chairman and members, I invite my colleague to add on the submission.
Mr. Chairman, I will not have much to say, but as my colleague's submissions, Lord Chairman, we direct what the senior colleague said about section 208, the EPDF Act, as far as the unlimited jurisdiction of the EPDF is concerned. But also, under that section, there is something to do with service offense. And the service offense is defined under the EPDF Act. Under section 1, 1, which service offence means an offence under this act or any other act for the time being with force committed by a subject while subject to military law. Our chairman, that is very important, especially subject to military law. Under the charge sheet that we intend to amend, the accused persons are subject to military law, specifically under section 117, subsection person subject to military law. And my lord, we proceeded under section 1G but also H of the UPDF Act. And the offences with which they are charged are provided for under the UPDF Act. So my lord, one has that such is not provided for, intended to mislead this one report. And lastly, my lord chairman, the reading of
tambula gye tutambulamu bannamateeka balina kyebawakanya nga bagamba nti balina lulimi gye balinze mu amendments to charge sheet. So gatulambulula ekyo muteeka n'ekimu
olwaleero mu kkooti omuwaabi wa gavumenti ategeezezza kkooti masho nti baagala kukyusakyusa mu mpaaba yaabwe mu lulimi lunnamateeka eyo tugiyita charge sheet. Ategeezezza kkooti nti baagala kukyusakyusa mu mpaaba yaabwe bayongereko munnamagye omulala gwe bayita John Olal. Bagamba nti John Olal munnamateeka manya munnamagye era akola ne Amadi Brigade ya UPDF. Era munnamagye oyo baagala kumugattako ku charge sheet eyo. So n'asaba kkooti eyimirize byonna ebigenda mu maaso ebawa omukisa basobole okwongera munnamagye oyo ku musango guno. Bagamba nti y'omu ye Dr. Kizza Besigye ne Hajji Obed Lutale kamulegeya abakola emisango egivunaanibwa. N'olwekyo basaba kkooti esooka eyimirize okugenda mu maaso n'omusango ebawa obudde bakyusekyuse mu mpaaba yaabwe. Kakati bawadde kkooti amateeka agabakkiriza okukola ekyo ekyenkyukakyuka. Naye bwe twetegereza amateeka nga regulation 66 gawadde kkooti, ate mwana wattu amateeka ago tegakkiriza ekyo, tegabakkiriza kukyusakyusa mu mpaaba ku stage eno oba okwongerako omuntu omulala. N'olwekyo tukitegeezezza kkooti era chairman bwatu nasooka ayimiriza mu nsonga eno mu musango.
Mu lulimi olw'amateeka omuntu nga Dr. Kizza Besigye ne Hajji Obed Lutale gwe mukiikirira babadde bawakanya ekyokubawozesa mu kkooti eno nga bagamba nti nga mugamba tekigwanidde kubanga emisango tebagitiza wano tu si bannamagye okwesibwa mu kkooti eno. Mukadde kano singa babongerako omuntu omulala nga munnamagye ng'oyo gwe bagambye asavinga kibalekawa.
Ekyamazima ffe bwe tutunuulidde ebigambo bya omuwaabi wa gavumenti mu kkooti eno tukizudde nti bagenderera okutulemesa okugobesa omusango guno mu kkooti eno. Omulundi Elias Lukwago munnamateeka munnaffe gwe yasooka okujja yategeeze kkooti eno mu mateeka nti tekkirizibwa kuwozesa Dr. Kizza Besigye wamu ne munne Hajji Obed Lutale kamulegeya mu kkooti eno n'abategeeza amateeka agagaana ekyo. N'olwekyo olwaleero olw'okuba nti bakizudde nti amateeka gabakwata ate kati bakyusa bayongerako munnamagye basobole okwewa obuyinza obuwozesa omusango ogwo. Ffe kye tulowooza nti kikyamu era tekikkirizibwa, tekimenyawo kiri ekyasooka mu mateeka tekikkirizibwa.
Akadde kano kkooti yo eri mu kuddamu katuddeyo munda twongere okulondolera byonna byonna ebiriyo tubikutuuseeko obutereevu.
If I may give you the facts briefly. the South African Court of Appeal allowed an appeal against the conviction of the appellant for treason. The appellant, a member of the military wing of the African National Congress, who had fled South Africa while under a restriction order, had been abducted from his home in Mbabane, Swaziland, by persons acting as agents of the South African state and taken back He was a member of the military wing of the African National Congress who had fled South Africa while under a restriction order and had been abducted from his home in Mbabane, Swaziland by persons acting as agents of the South African state and taken back to South Africa, where he was handed over to police and detained in terms of the security legislation. He was subsequently charged with treason in a circuit court. And the appellant had, prior to pleading, applied for an order that court lacked jurisdiction to try the case as his abduction was in breach of international law and thus unlawful. This is a precedent which is on all fours with this, and the court had the occasion to say this. We note that in this instant case, the state of South Africa violated the territorial integrity of Swaziland by sending its own police to abduct the appellant from Swaziland. The South African Court of Appeal also considered that it had no jurisdiction to try him, given the breaches of international law that South Africa had been privy to. Therefore, they said, therefore, the other Tanzanian case which is cited here is distinguishable from this one. So I invite this General Court Martial to treat that as a redundant submission because it has no basis in the law. And the decision that was made final in that particular matter is what I read earlier, that court has no jurisdiction to try a person who was abducted from another jurisdiction by agents of the state authority exercising power in the area of jurisdiction of the court. That puts this matter to rest, and this is a court, this is a constitutional court whose decision is binding on this General Court Martial. Then regarding the definition of the defense forces and the incurably defective charge sheet, because we maintain it's incurably defective. When you state in the particulars that a pistol and ammunition found in possession of Colonel Dr. Besigye and Hajji Obed Lutale at Riverside apartment in Kenya, which is a monopoly of defense forces. Mr. Chairman, it would be stretching the UPDF law to levels of absurdity to state that a weapon found in Kenya is a monopoly of UPDF. That would be absurd. That a pistol found in Kenya is a monopoly of UPDF. That would be an absurd. This is the defectiveness that we are talking about in the charge sheet. It cannot be. And it would only be a monopoly of UPDF. And even here locally, by the way, Mr. Chairman, there are authorities to the effect that a pistol is not a monopoly. But those are matters that can be handled at a later stage. It's not a monopoly of the UPDF, a pistol and ammunition. Now, on the question of an MOU, this sounds strange. Wouldn't this submission coming from lawyers who went to the law school and they are here dealing with matters of this nature, brave as they are? Because, Mr. Chairman, we are talking about matters of life and death. And we are talking about an MOU to override a written law. When you look at this act, the Extradition Act, which commenced on the 20th of July 1964, in the long title, Mr. Chairman, it's very, very clear. an act to provide for the extradition of persons accused or convicted of crimes committed within the jurisdiction of other countries. This is an act. An act, this is the long title, an act to provide for the extradition of persons accused or convicted of crimes committed within the jurisdiction of other countries. This law was not made in vain. This is the only framework we have under the law that can be invoked to have an accused person transferred from Kenya to Uganda. There is no any other framework, legal framework. I wish they cited the law under which that MOU was executed. At least even laying it on the table that this is the MOU. And the law which provides for elaborate mechanisms you have to go through before you get one transferred back to Uganda. And you are saying that one can be jettisoned by a mere piece of paper called an MOU. Mr. Chairman, that should be treated with the contempt it deserves. On my side, the final submission, Mr. Chairman, the issue of Article 2 or Section 208 and 9. Section 208 of the UPDF Act. Mr. Chairman, this law, this particular provision, was not meant to operate in isolation of other legislations. No. It had to operate first and foremost within the existing constitutional order, because the Constitution is supreme. My learned friend here, Senior Counsel, and my brother Kalibara here, they have cited the relevant provisions of the constitutions which are compelling, which take precedence over any other legislation. But even then, the UPDF Act comes into play after you have complied with all these other requirements, with all these other laws, the extradition law, the Constitution, and all this. So that's when it comes into play. But if you cannot cling on one particular provision and say, it gives us universal jurisdiction over all matters worldwide. So the other argument that we have not particularized the defects in the charges are equally neither here nor there. Because, Mr. Chairman, we clearly indicated that the charge sheet, the way it is structured, when you look at it on the face of it, you can see the defects, the charge sheet itself. Because, yes, my learned friends have cited section 6, 7, and 8, which talk about the particulars of the charge sheet. Exactly this is the point we are raising in this amended charge sheet here, where they are stating that the county 4, county 3, and the 4, together with actually county 5, where they are talking about rounds of ammunition and a pistol. Here we reiterate our earlier submission. We are saying this particular, these particular counts do not spell out exactly the acts, the impending acts of the committed by the accused persons in regards to the defense forces here in Uganda. This is the point we are making. The impending acts in regards to the defense forces here in Uganda. Let me say it differently. If indeed they wanted this section 28 and 29 to come into play, they should have expressly stated that they were found in possession with the firearm, with the pistol and ammunition, which are a property of the government of Uganda. If that's what they had said, that would be a different case. That which are a property, subject to proof of course, which are a property of the UPDF. That would be their case. But it cannot be sufficient to say that whoever is found in Kenya with a pistol and ammunition, he offends the UPDF Act. There are so many people in Kenya right now with pistols and rounds of ammunition. Would they want to suggest that those are all subject to martial law here in Uganda? This is the uncertainty we are talking about in this country, that it's not particularized, and it is duplex in nature, that it purports to bring all these issues of ammunition, of the pistol and whatnot, all lumped together to make it as if it's one count which is put here. So basically, on the question of evidence, as I wind up, Mr. Chairman and honorable members, that we should have laid evidence before you regarding the way they were transferred here. Mr. Chairman, the charge sheet speaks for itself. The record is very clear before you that all they are complaining about, all the issues they are raising, Kenya, Switzerland, and elsewhere, there is no single impande act here that offends the law which they are putting in the particular charges of the charge sheet. Nothing. So all they are talking about are acts which are alleged, which have been alleged to have been committed in Kenya. And in this particular case, Mr. Chairman, and in this particular case, Mr. Chairman, we want you to find that these acts complained of here can only be, first of all, processed by those respective jurisdictions. Kenya, Switzerland, or Greece, but not to be directly brought here before you. I ask my colleagues if there are other specific issues to respond to or comments. I thank you, Mr. Chairman.
Just a single issue with your permission. The prosecutor says that, or rather, the prosecutor says that they prove how the accused were brought here. I don't think so. It is once the defense raises an issue on how the accused were brought, it's up to the prosecutor to then rebut by showing the court that they were brought here legitimately. If there is an MOU, let it be laid on the table. I have cited the extradition law of Kenya. It's Cap 75 and it is online. Anybody who is being extradited, even if they are willing, they have to go before a court so that an order is issued. So if they have an order, let them show it. If they have an MOU, let's look at it and see whether it fulfills the order. We've also cited Article 129 of the Constitution of Uganda, which limits the territorial jurisdiction of all courts, the courts of judicature and courts named under an act of parliament, and that's where this court martial falls. There is no other statute that can be greater than the Constitution. So the Constitution limits you to Uganda. Therefore, kindly discharge this gentleman and let us all go.
Mr. Chairman, if you allow me the latitude, the prosecution has miserably failed to defend the charge sheet. Mr. Chairman, the prosecution